and welcome to the Divorce Allies. It is legal week, and so we have our favorites on here. I'm Emily Flowers. I'm your divorce mortgage planner. Melissa couldn't join us today. I think she's in a trial or something. So she is knee deep in all the things that she does. Today we have Adrienne, who is also Melissa's business partner. Adrienne is a former attorney, and she does legal and accounting work with Melissa on all of Melissa's client work, things like that. She kind of keeps it all rolling. And then, of course, we have Tracy B. Joining us today. She is our family court strategist or our pro se advocate. And we are so lucky to have these two women joining us today to give different perspectives on planning in the dark and certain matters that pertain to your case and what might happen legally if you're with an attorney or maybe going pro se, or if you'd like to get an idea of what the pro se side would do if you are maybe in between attorneys or you've been fired by your attorney or something like that. So we'd love for you to participate, ask questions, throw in things that you would like to know in the chat, please. And we will definitely be attacking those as we go today. So welcome, ladies. I appreciate you so much for being here. And today, Melissa wanted us to really talk about, still talk about planning in the dark. It's such an important aspect of your process. I don't know about you, but a lot of people just kind of jump into the filing part or other aspects. Okay, I'm getting a divorce. He just told me I'm going to hire that attorney real quick, and they're going to guide me through this process. And there's many people on here who have they've done exactly that. They've spent $50,000-$100,000 already, and they're like, wait a second, nothing's getting done. Now what do I do? So we will have people from all aspects, and it's almost like starting over, right? After, if you've been fired by your attorney or you've decided to fire the attorney or whatever, you're basically starting almost back at square one, I would think. Is that correct?
Almost, yes. Yep,
So,
pretty much.
What would you
everything
say?
stays filed. Like, it's not like everything comes out, but process-wise, like all of your financials, if they're already filed, will stay in the court. But do you trust that what your attorney did was the attorney who fired you or who you fired? Do you trust that those are accurate and reflective of your position? That becomes the question.
Okay. And then what if, you fired your attorney or you got fired by your attorney and you didn't hire another one and you decided to go pro se? It's still all filed, right? Except for now what? How do you pick up where it's been left off?
Well, if you decided to, but whether by force or choice, your pro se, your first stop is to, try to get your file from the previous attorney and see, get an idea of what's been done, what needs to be done. And then you should definitely go to the court and find out what the attorney gave you sort of reconciles with what the court has in its file, in its records. And then you compare the two, and now you need to decide what you're going to do next. Do you want to revisit discovery? Do you want to revisit some of the financial disclosures? Do you want to move forward with a motion that should have been done or should be done? Do you, in addition to, of course, letting the court know, because some jurisdictions you have to let the court know that you are now pro se. So it's the equivalent of a notice of appearance by the attorney, just indicating to the court that you are pro se. Some courts have a formal process by which pro se need to do that. Not all of them do, though. But And in most cases, when an attorney withdraws, then that's pretty much enough for some courts. In New York, that's enough. The pro se doesn't need to file anything, but those are the main three things you need to do to be sure that, hey, you may need to start over. Not starting with the petition and the response, of course, but starting with, like I said, the discovery, the financial disclosure, and anything else that might have was done, not done correctly, not done completely, or wasn't done at all.
Yeah, I would imagine you would have to pay your attorney too before they're going to release that information to you. So
Yes.
if you were behind.
Yes, because if you have an outstanding invoice, yes, they're not going to give you the file. And the other thing is, once you do pay them, to ensure that you ask them for a complete file. Now, some attorneys will say, hey, I'm not going to give you everything because some things are work product and I don't have to turn these things over to you. And, depending on what the rules are, they may be well within their right. I've had some instances where attorneys said that and the pro se was able to still get those things because, when they got me involved, that's what they had no choice but to provide that stuff. But, because there's some rules where, when you're pro se, they are subject to any communication. So because they are the client. But again, every state has different set of ethical rules and exceptions, of course, and case law and precedent and so on and so on and so on.
Sure.
But yeah, so they need to ensure that, because sometimes attorneys will withhold any communication with opposing counsel, and you don't know what's been said on your behalf. You don't know what kind of negotiations, what kind of concessions have been made, and you may never know. And so now you're walking in blindly, thinking that you're picking up where the attorney left off, and you don't even know where they left off. So it's important that you try to get the complete file, because even when you go to the court to get their copy of the file, it's not going to be complete. It's only the court's version of. Some courts you don't have to file the discovery requests or responses with the court. It's just a voluntary exchange between counsel or the parties. And so you may not see that filed in the courts. Again, in New York, you don't file discovery in the court. You don't. It's just not. So you need to, request a complete file after you pay the invoice in full, or whatever arrangement you make with the attorney to pay it in full.
And I will just add to that is everything you communicate with your attorney is privileged, remains attorney-client privilege. So if you get subpoenaed for communications with your attorney, you can still personally object to that. So if you get a file and it has communications between you and your attorney, you don't have to turn any of that over to your opposing party. So anything that was attorney-client privilege will remain attorney-client privilege. Just to, you are not, by firing or getting fired by your attorney, you're not giving up your strategy or what you discussed with your attorney. That may be their notes that they may not give you in your file. That would be the work product, some of the work product that they may try to withhold. But that would be still not discoverable, because I think we get people very anxious. When anything changes, they're like, well, what about what my old attorney told me? It's that's still not discoverable. So,
okay. Well, that's helpful. So what if, okay, let's now flip back to that person who's contemplating divorce, and they have been listening to the Divorce Allies and they haven't jumped the gun, and they have, they're going to plan in the dark, right? What's important about the financial disclosures? What's important to fill out? Can you do it yourself? How detailed do you need to be? Tell me a little bit about that, Adrian, from the legal side, if you're going to be hiring an attorney. And then we're going to flip to Tracy B to let us know from a pro se standpoint where that's going to go.
So on the legal side, sort of the first part of the question is how detailed, and what is it and how detailed? So your statement of property needs to be complete. It needs to be everything. Your statement of property is the court disposing of all marital property. Now, you might not know about everything, but your statement of property should list everything you know about. You should be compiling a statement, even if you just have oh, my husband gets notifications from Merrill Lynch. You can list Merrill Lynch accounts unknown to your lawyer, and they're going to know that they need to potentially subpoena that. They're going to know to ask discovery about that. A lot of things where you just remember seeing a piece of mail from a bank, or you saw an email from this brokerage firm, or whatever it is. You might not know all the details, but any details that you can get into the property statement is helpful to make sure that you have a complete picture, especially where, it's easy to forget about an old 401k plan and an old employer that I never rolled over. There's a lot of those sorts of things that don't intentionally necessarily get left out, but sometimes do. So on the property statement, very detailed, as much detail as you can get. Grab statements. If you can get a year's worth of all of your statements, that is great. That will help you prepare your financial disclosures, as well as help your attorney understand and be able to look if there are arguments about misuse of funds or dissipation of marital assets. On the financial statement, that is the income and expense disclosure. And some states, again, like just to be clear, in Missouri, income and expense and property statement are done as two different things. Other places, financial disclosures is one document. So I will talk about them as two things. They're going to go together, but they are looking at different considerations. So your income and expense statement, or those details, in my experience as an attorney, if my client wasn't asking for spousal support or child support or any sort of ongoing support, those numbers are still important. You still need to fill it out, but there's far less concern about the level of detail that you have to get into. Whereas if you're asking for child support or spousal support, taking a year's worth of statements of all your credit cards and banking and looking at what your actual expenses were is going to become much more important. Now, our paralegals did that for a lot of our clients. My cases were typically very big. And so you would get a year's worth of statements from your client, and you would start to prepare that income and expense. We would call it preliminary. I would never say that the first thing we file is going to be final, because we are probably missing data. There's probably pieces that are the other spouses, and we need to kind of unwind some expenses from that, from household to individual by the time you go to trial. But it's a preliminary statement of income and expense. You're going to do, if you don't have any support issues, it becomes a lower, kind of a lower threshold. If you can prove that both people have enough income and enough to cover their expenses, support doesn't become an issue, and that income and expense becomes much less important for the court. So more detail if you're gonna ask for support, less detail if you're not gonna ask for support on the income and expense. Property statement, always as detailed as you can get as much supporting documentation as you can, especially if you're concerned about your spouse moving money in the future or any of that. You can be looking back at those statements and seeing if there are transfers to another account. That would go on the property statement. That might go to the subpoenas that your attorney is going to issue. That's the sort of stuff that we're looking at when we dig into those annual 1 year of statements. I'm making a list of all those credit cards that are getting paid off. I'm making a list of that mortgage company that's got a monthly recurring expense, all of those things, your car, vehicle payments. You're going to see all of that in that 1 year of activity, including taxes. So that's another piece, is you're going to see your taxes come out, your property taxes, your income taxes, any sort of payments like that. So 1 year is really ideal for preparing that statement of income and expense if you're going to go into support. And your attorney is going to ask you for that. And in the represented world, you can plan in the dark, and Tracy's going to talk about the pro se, that's what you're going to do. In the legal world, your attorney, their paralegal, their administrative assistant will probably be helping you prepare those sorts of statements.
Okay, that's good information. I have a question for you. I helped a friend fill out her documents. This was not in Illinois or Missouri. It was in California. And it was interesting because I'm asking, so it asks about collections, or meaning maybe a sports memorabilia collection or a coin collection or something like that. It asked about different things in your home. What's the cutoff of amount that you put on there? Because it was jewelry. Well, what kind of jewelry? What kind of furniture? What kind of, yeah.
So our favorite legal answer, it depends. It depends on your circumstances. It depends on your case. If you have, in Missouri, it's called household goods and things. I can't remember, but household goods. And I really don't put that much on there. That is typically like the last thing I worried about as an attorney, because for the most part, we found that people that I was representing were able to kind of separate their household items themselves. So in a represented situation, we didn't necessarily list them. Now, if we were talking about $100,000 wine collection, if we were talking about vintage guns, if we are talking about, very valuable artwork, those sorts of things, maybe in an aggregate way of like artwork to be determined, watches and jewelry, typically what ends up happening is you're going to keep what's in your, like, females are going to keep female jewelry, males are going to keep male jewelry, or if gifts have been exchanged between partners, they're going to keep the jewelry or the watches or the things that they've been gifted. Oftentimes those sorts of collection things have started before the marriage, and you get into some messy separate property issues with the things like the coins or the stamps. So there's a lot of components to collections, and I think every state's probably going to be pretty different on how they approach those. But in Missouri, we really didn't, in my experience, we didn't really dig into those things until the end. And for the most part, by that point, people are not in the mood anymore to fight about too many things after you figured out all the other financial things. That can also, though, be a pivot point. You just got new living room furniture. You just got new bedroom furniture. That can be something where you're like, okay, just take it. Be done with it. I don't want to fight about it. And it can give you some more things to negotiate around, especially if those were expensive things more recently. But you are realistically, if you have a 10-year-old couch, it's depreciated in the view of the court and in the view of accounting. It has no real value. It might have sentimental value. It might have personal value. But unless it is like an antique, you're probably, most of your furniture and most of your household goods are going to be the things that are a pain in the butt to replace, and they cost money. But the court is not going to get into going through your house and telling you this pot's yours, that pot's yours. The court doesn't have the time for that. And your lawyers, in a large part, it's going to be really expensive if you go through lawyers trying to suss those things out. Not to say I haven't sat and watched people divide up a collection. I pick one, you pick one, I pick one, you pick one. It happens, but for the most part, they're going to do that without the lawyers present.
Gotcha. Thank you for clarifying. Tracy B., let's go to the flip side. Let's go to the pro se side of that question, and then we're going to tackle a listener question after that.
Well, pro se and financial disclosures affidavits go way differently than when attorneys are involved. Okay. And I'm going to distinguish pro se against pro se as opposed to pro se against an attorney. The reality is pro se, especially if they're pro se, they're both pro se, the financial disclosure is not going to be as significant because a lot of times pro se against pro se don't go to trial. And honestly, that's when the financial disclosures really, really matter. Unless one is seeking for temporary support, then that's what the courts will rely on to help make its determination for temporary financial support, is that the financial disclosures completed by both parties. But if that's not happening, then those things, and when the pro se come to me and they're against pro se and they're really freaking out about completing the financial disclosure completely and accurately, I usually tell them to do the best they can, because as pro se, you have to pick your battles. And that's certainly not one of them that you want to be, lamenting over to the point where you can't focus on the other aspects of your case. And so, yes, it's still an affidavit. It's a sworn statement in most jurisdictions, so it still should be done accurately. But to actually wake up at 3:00 in the morning because they're concerned about whether or not you're filling in everything and have everything they need, I usually tell them, hey, this is not something that you really need to lose sight of. Now, when there's an attorney involved and you're pro se against an attorney, that attorney is probably going to be a little bit more of a drill sergeant with getting you to complete it and get it submitted on time. Sometimes it's attorneys who are against pro se will do that, not because of the substance, but because it's a practical matter. It's a tactic that you can use to sort of use some sort of tutelage to get the pro se to fall in line quicker. And a lot of attorneys will do that against pro se with every respect of the case. They will use procedure to kind of, catch them off guard, or kind of sort of swoop in at a vulnerable point. And the financial disclosure is definitely one of those tools that they use that for. But I say to people, you have to, take your time, gather as much as you can before you even sit down to even attempt to complete it. Take your time, do it over time so that it's submitted in time by the deadline. But if it's not, then don't kill yourself, especially pro se against pro se, because in most of the pro se against pro se cases, neither one does the financial disclosure on time or completely and accurately. They just don't, because a lot of them don't know how to do it. They don't know what they should disclose, because a lot of it for them, and I actually encourage this, is strategic. And everything is strategic once I get involved from beginning to end. So whether they should fill out the financial disclosure completely and accurately and on time and submit it, it's a matter of strategy. Honestly, it's a matter of strategy. Again, especially pro se against pro se. Now, when an attorney's involved, yes, I'll say, hey, yes, take your time, do it, but get it, make sure it's done. Because the thing is, when you're pro se, most judges, most jurisdictions still are not fans of pro se. So anything you can do to get the judge to be in your favor, to get the opposing counsel to be in your favor, and to not assume that you're going to be the typical problem pro se litigant, is to follow rules as much as you can. Adhere to deadlines and timelines and follow rules. But from a strategic standpoint, yeah, it totally, it totally depends how much I'm going to push them and encourage them to do that, the way it's supposed to be done, when it's supposed to be done.
I would imagine going pro se, you would also want to study etiquette. Courtroom etiquette and just procedure etiquette, things like that, just so you aren't the problem child of the courtroom, would be my guess. And how does one do that? Can I do that on chat? Can I do how does one figure out? Because I just was telling these two before I came in. I'm like, I've never been in a courtroom. I've never needed to be in a courtroom. I didn't. They usually don't bring in a mortgage expert as an expert witness. I mean, I can, but for the most part, not really. So I don't know what to expect. How would I figure that out?
Go study your judge. Because there's some universal generic rules across the board, but your judge may be a little bit OCD. Your judge may be a little nuanced, maybe, have some idiosyncrasies that are different from someone else. Go study your judge. You'll get the lay of the land just by observing them. And
can I just go into the courtroom and watch?
Some places, yes. Since the pandemic happened, some places have closed off the courts and they don't allow the public in, even though we all have a constitutional right to be in the courtroom. Some judges are using, the pandemic, they were waiting for that opportunity to say, close courtrooms, because there's a lot of things in the courtrooms that they don't want you to know. But if you can't, then go and sit in the hallway or, the traffic place where the litigants are coming in and out, and you can stop them and ask them. Ask the court clerks, ask the court personnel, ask the staff how that specific, if they've been in the courtroom, in the court building for a significant period of time, they know how each judge operates. So if you can't observe your judge directly, ask around, go and get consultations and ask other lawyers. But there's a way you can actually find out who your judge is and how they like to run their courtroom. And that's one thing I really emphasize with pro se is one thing you want to do is learn your judge and speak your judge's language, come in with the decorum and the etiquette that your judge prefers. That's one way you will absolutely get the judge to say, hey, wait a minute, this is not the typical problem pro se litigant. This litigant actually has some professionalism, some sort of, decorum. And you know what? I'm not going to automatically assume that they're going to make this case drag on longer than it needs to be. So let me give them a little bit of grace.
Okay. I like that answer. Yeah, Adrienne.
Yeah, I will add on, because what Tracy is saying is exactly what when you talk to a lawyer, when you interview a lawyer, ask them about your judge. The things she's saying about sitting in, that is what your lawyer should be doing. So when I practiced, that was often, we had judges change out every 2 years. Like, they don't all sit on divorce court. Most of them hate divorce court. It is their least favorite place to be. It is emotional. It is not always logical. They don't like it. for the most part, not saying all of them. Never everything. We have to caveat everything as sometimes. But yeah, your lawyer should know the judge. There is a judge in St. Louis County who had a proclivity that required everyone to come in and put everything on the record, even if it was if it was represented by two attorneys and there weren't kids. Everybody had to come in and go on the record. We took change of judge always because nobody wants to go in to the courtroom when you hire an attorney. It's what your attorney should be doing. Another judge made you come in if you had a child, you had to put custody on the record. Even settlements represented by attorneys with guardian ad litems representing the kids still had to come in and put it on the record. So your lawyer might be strategically picking judges because of their proclivities. So that is something really important to your lawyer and why you want to get a lawyer who practices in the area, family law, but also in your region. Like you want to be, do you have most of your cases in this court or that court over there in another county? Because they operate differently. The judges operate differently, even within those court systems. They all have their preferences. And then the other thing, Tracy made a lot of very, very great points in there is you will watch, if you go watch your judge, you will watch how they respond to litigants. So look at the people who have attorneys, look at how they're dressed, look at how they're behaving, because their attorney should be coaching them. And if you have an attorney, your attorney should be coaching you on how to present yourself. There were definitely clients where I wanted them in a suit and a tie, and that was because the way we were going to present them. I had clients where I wanted them to be a little bit more dressed down. There are tactics in how you present yourself to the court and how your attorney should be advising you to present yourself to the court. They should be prepping you for court. They should be prepping you for deposition and making sure that you know what you're getting into, how to look and how to hold yourself. For the most part, settlement conferences or update conferences or status conferences or whatever we want to call them in every court. For the most part, we didn't have our clients there, but when we did, there was a reason and they were advised about what to say, not say, and how to act.
Wow. No, that's such good information. It's funny. So one of my best friends is a divorce attorney, believe it or not, and in the county that I live in. But she's also very well versed in a lot of the counties around here, which is uncommon. So a lot of them just stick with one county, right? So there is a thing about the attorney being respected by the judge as well, and that the judge wants to work with them. And she also said that in our county, like in the basement of the courthouse, there are people just like her, and she is one of them, that will, if you make an appointment, you can actually talk to her free of charge, because she said, I don't know what they call it. Maybe you will, but you can just sit and ask your questions or get help filling out a document or whatever in the time that you blocked, and it's a free service. I think she's won some awards for free help.
So over there at the Land of Lincoln, it's so most counties.
Oh no, it's apart from Land of Lincoln. Yeah.
Wait, what?
It's apart from Land of Lincoln.
Oh, okay. Mm-hmm. Most counties, that's different that if it's through the court system, but most counties and most areas are going to have a legal support network as well for people who can't afford attorneys that are going to be supportive on those things. That is new to me though. I definitely did not sit in a basement and answer questions.
That was something new that I learned. And I was like, does every courthouse have this? And she was like, I don't know, but Madison County does. And I was like, oh, okay, sounds good. So I've been telling people in Madison County to go do that. Okay, we have some questions, and I know you guys are just gonna come at it with just amazing information. So one person says, if your toxic ex is stalling the financial and discovery process, how can you try and move the process along through mediation? Given mediation is voluntary, even if you come up with an initial settlement offer, can a difficult spouse simply not choose to ignore the mediation request? In other words, with a toxic ex, is there any value to trying to make the first settlement offer?
Who should go first?
We'll do Tracy B first.
I love that. I get that question so often, actually, and I love it. Again, from a strategic standpoint, you should make a settlement offer anyway. You should always make, as a pro se, you should always make an offer. You know why? Because most judges want to see you be proactive, and they want to see you exemplify the desire to stay out of their courtroom. So if it doesn't work in mediation and you make it to the judge and the judge sees that you are the one really trying to, they'll say in in the eye of being efficient and all of that, and we know that, but judges don't want you in their courtroom. So if they see that you've made some intention to resolve the case, which to them, like I said, it means, hey, I don't have to deal with this. Again, you've earned a favor, you've earned a brownie point, you've earned a credit, a merit on their behalf. And so, yes, you should definitely make a settlement offer, never mind who the recipient is. You're not doing it necessarily to you. I mean, of course, you want them to accept it, but you're doing it when you're pro se, you have to think strategically. Everything is not done, one and done. Everything should be done in context. You should have a long game plan. And that's definitely one of them. So yeah, you make your offer. If they don't comply with turning over discovery or financial disclosure, then you're going to say that. You're going to indicate that. You're going to make that clear. You're going to make it, when I say make it clear, you're going to email, you're going to memorialize that. But it's not going to deter you from making an offer. You're going to put the offer in conditioned upon you receiving all of the necessary information, because you don't want to make uninformed decisions. Your decision should still be informed, and they won't be informed if you don't have everything you need. But you can still do that and include that it's conditioned upon, updated information being provided when it should be provided, blah, blah, blah. But absolutely. And go to mediation, because mediation is not just about resolving things, and it's voluntary. It's not just about, again, it's a strategic move you're making by going to mediation, because you shown the court, not only did you try to settle, you went to mediation with a good faith effort of resolving this case. And it's not your fault that it didn't work. So all of that, yes, because if it doesn't, by the time you make it to the judge and the judge gets wind of all of that, then hey, you're not the problem pro se litigant anymore.
Yes, I love that answer. And my thing is with starting with a settlement offer, if you're just putting a settlement offer together with all the things that you want in the way that you want them, how are you losing? Like that, all you're doing is saying, this is what I want, right? And make them come to you. And if they're here and here, guess what's probably going to happen? Here, so I don't know if you have much to lose, but I know that there's times where you wouldn't. What do you think, Adrienne?
Yeah, I mean, I will say, because I'm sitting I was a lawyer, I did not do mediation, mediation is not right for everybody. That's why the court system exists. I would say try to mediate. I mean, I am pro mediation. A lot of states now have mediation mandates. Before you can actually get in front of a court, you have to attempt mediation. But the reality is not everyone is coming to mediation with the same intentions, the same intent or behaviors. And so if someone is not complying in mediation, you may have to start the legal process. You may need to start, if you're trying to mediate before you filed, you might have to start filing for divorce. You might have to start making motions to request documents. You may have to start that process if the mediation process isn't working for you. No, I mean, I think Tracy and I sit on different ends. If Melissa is here, she sits in the mediation. Tracy sits formerly practicing attorney doing pro se, and I sat in the practicing attorney. Those are all different modes to get to the same end. So they're all different methods. There's a lot of different things, and not every one works for every person and every situation. So I think keep that in mind. Like mediation is a great, great tool. But if somebody isn't coming to mediation with the intention of mediating, you're not going to get anywhere, because you can completely stonewall that process by not playing by the rules of mediation. I mean, not everybody is made for it. And some people will not comply unless there's a court order. And that's just personalities and perspectives. Yeah. Mediation, again, best place to start, trying to solve your problems even without a mediator, like trying to mediate your problems and create a settlement offer with your spouse outside of the court system. Great. But that's why the court system is there. As Tracy said, The court doesn't want to see you. They want attorneys. The system is set up with attorneys. They want everything to be simple when it comes to them. I think we can all kind of get there. Is we would much rather have somebody write it down and tell us what they want us to do than try to figure out all of the moving parts in a family, in a household. The court isn't an expert on your household. The court is an expert on the law of the state that you're in, but they don't know you as well as you do. And that was always the risk of going to trial, is that the court might do something that you don't want them to do and your spouse doesn't want them to do either, but the court can.
Right.
So getting to a settlement is, going to have, you are going to maintain that control by settling. But if they won't, you have to go to the next step, because otherwise you're just going to be very frustrated by the process, which is already very frustrating.
Yeah. Melissa's been noticing a lot of mediation not done well too. So she's even starting to be like, all right, well, let's start with consultants, because it's private, and so she's been even trying to tweak it in another different way, just because you just never know what you're going to get. And a toxic spouse also in mediation can be difficult, because they don't care about the rules. You're going to follow the rules. They don't care about the rules, so they're throwing them out the window. And the more money you have, the more you really don't care about the rules. All right, we have another person, a YouTube person. Yay! I'm in California, pro se. Opposing side has attorney. I've done my own legal research and have adhered to deadlines about preliminary discovery. My ex and his attorney have not. They've lied, hid, failed to submit financial disclosures. Also, opposing counsel was very favored unethically by biased judges. I've had a DVTRO. So opposing counsel retaliated with baseless silver bullet cross DVTRO. Also failed to serve until after it expired, over 2 years later. We all haven't had an evidentiary hearing. It's a lot. I don't know what some of that means. So I'm going to
guess that a DVTRO is a domestic violence temporary restraining order.
That's what I would.
Since this is all Tracy's lane, I'm going to let her start. And
that is what I would assume it is as well. But yeah, Tracy, tell me. I don't know if there's a question. It says opposing still hasn't provided his tax returns, W-2s, over 2 years later. So that was her final comment.
And what I don't know is what she has done to this up until this point. Did she file a motion? Is the judge aware? What attempts have been made? I will say this again. I was a practicing attorney doing family law, and the spin that I have on family law then and the one I have now are completely different. Because when I'm working with pro se, I see court now from the pro se litigant's perspective, and I see attorneys as opposing counsel and what they're doing from the pro se litigant's perspective. And as an attorney dealing with that, I know what to do, and I know I know how to handle it. But when you're pro se, you don't understand, you don't even understand the subliminals that's being sent to you when they're playing these games and they're doing these tactics. And so what I will say though is that a lot of times, I'm sorry, Adrian, you wanted to say something?
I was just going to say, the tools.
Yes.
Like they don't know the tools.
Yes.
Sorry, that was like my one thing. I was like, that's
exactly it. That's it. They don't. And this is one of the things that I pride myself on, enlightening them about. But I will say that a lot of this is by design. Them not cooperating. They know the judge. They know what the repercussions are going to be. They know, they understand. So they have that leg up on you because they know. But you still have the right. You have the right to actually have, information. You can't make informed decisions without having those things. So what do you do? I can't answer that. I can't give you legal advice. But what I can tell you is that it's for you to decide now strategically what's within your purview, your realm to do procedurally, practically, strategically. There is something you could do. You need to, I can't tell you exactly what that is because I don't know anything about what you've done. I don't know, what's at stake. I don't know any of those things, but I do know that if you don't do something, it's going to, be them actually dictating and navigating the direction that this case is going. And you're just going to be basically, have to capitulate. And you don't want that. It's great for you to get a hold and a handle of what you can at this point so that you have sort of, your input as to the direction your case actually flows. What I also will say, a lot of times I tell pro se litigants when they're in situations like this to, ride the wave until it's time for trial. And a lot of them will say to me, trial? I don't want to go to trial. I am a fan of trial. Yes, I'm a fan of pro se going to trial. And believe it or not, pro se actually go to trial. I've coached quite a few who did their trial on their own, and some of them prevailed. They actually prevailed because we worked long and hard enough on that. Because there are times when you go to court and your case is dragging on, it's protracted, right? You're going to court every 4 to 6 weeks, sometimes 4 to 6 months. You think the judge has a continuum of your case? You think they remember you every time you come into their courtroom? You think they remember the facts and the details of what has been done? They don't. They don't. They read the notes right before you walk into the courtroom. If it's them even reading it, they have a court attorney or a law clerk or something who summarizes it for them, then that's what they do. So your best chance, your best opportunity to get them to hear everything and to listen and to be your captive audience is at trial. And a lot of pro se litigants don't understand that those long delays in the project, all they're seeing is this case is taking forever. But from opposing counsel's part, they're thinking, oh, this is working in my favor because I'm actually dictating, I'm navigating, I'm steering the direction of this case. And so if you don't have a lot of leverage, if you don't have a lot of opportunity to take over or to at least semi-control where this case is going, move it to trial. Hey, let's get a trial date on the calendar quicker, sooner rather than later. And not everybody is going to go to trial because they're doing that, because some cases will settle at opening statement. It happens all the time. But just let them know that you're ready to pursue that route if you have to, because these games they're playing is not working out to your advantage at all.
Adrienne, do you have anything else to say on that?
I would just reiterate what Tracy said, what you have done in any circumstance, like getting somebody to advise and advocate or explain what Tracy's saying she does for her clients, all of those nuances. Every case is different. Everybody handles things differently. So it's hard to make those blanket, it's hard to advise on a blanket way. I will say it can feel like when one person is represented by an attorney who knows the judge, you can definitely feel bias. There's also, I'm not implying that there isn't bias or is bias, but it can feel that way because they have a personal relationship. They know each other. All of the every attorney I worked with and every judge that I worked with, by the time I finished practicing, I knew them. I only practiced for 4 years, but I could see them in public. I could say hi to them. You become a part of a system as an attorney or a judge. It is familiarity. It is not necessarily that they like you more or less. There is familiarity there. And lawyers and judges, judges are lawyers who've become judges. So they speak the same language, which can be what you feel is can be a biased appearance, not necessarily. Now, there are definitely judges that have favorite attorneys, not saying that doesn't happen, but it's hard to kind of ride that wave on your own and try to figure that out because you don't know the judge. The attorney does on the other side. And you're not going to get advice from me or from Tracy or from Melissa about any specific judge in your area because we don't know them. That's when, having an attorney becomes potentially the move. But also, I never wanted to put things on trial. So I'm like, Tracy and I have very different strategies because that was in representing people. I always thought settlement was, I settled every case. We had 2 trials in my entire 4 years. I don't like trial. It is not the skill set that I have. But it is definitely a tool and a tactic to move things along. If there is all of this, digging your heels in.
Okay. So I thought it was an appropriate time to go ahead and post Tracy B's free webinar that's coming up, by the way, in case you want to hear more about her. She also has an amazing podcast I listen to on occasion. There's really good information in there. So if you have like specific pro se questions, reach out to Tracy B. She'll help guide you along. She'll do, you know, she knows what she's doing. So she has her own company that based on just that. So it's a great way to go deeper with her on your individual case. Another person said, should you still offer settlement while contempt for discovery before hearing coming up? And can you please speak on subpoenas as pro se? Tracy?
I really don't want to answer that first question because, again, it's a matter of strategy. Offering a settlement when you have a motion for contempt pending, from my strategic mindset, sounds counterintuitive, but there's a lot more context that I'm missing where it may actually benefit you. I don't know. I just want to add to from the previous question that when you're making offers or settlements, they should not be out of the sky. They should be reasonable, because the purpose of me advocating or suggesting that you do that, it kind of flies in the face if you're just making these outlandish, pulling from the, out of the sky offers, because then the judges are not stupid. They're going to look at it as like, okay, I wouldn't have accepted this either. This is not a good faith offer. So, come on, let's be reasonable. But as far as subpoenas are concerned, the subpoena process is very, very nuanced. It's very court specific, if I should say, especially as pro se. If you are pro se and you're thinking about actually issuing subpoenas, please, before you start, understand the process in your court for doing that. Go to the clerk and ask them what the process is, because some places the judge needs to sign, some places it's just the clerk. Some places, you need approval. Some places you don't. You absolutely need to understand. It's so much so that I don't even do subpoenas. I don't even help my clients with subpoenas anymore. I have a friend of mine who actually runs a company, a business, that's all she does is subpoenas, and she does subpoenas for pro se.
Yeah. Is it the only subpoenas lady that we've
Yes.
talked to? Yeah.
Yes.
Okay. Yeah. We've been talking about her a lot. Welcome, Melissa.
Hi, Melissa.
We're happy to have you.
Hi, how are you?
Good. We're working through some questions. We have already been talking about filling out the financial disclosures, but we haven't gotten much further than that because we are working through questions. We have actually one more. I wound up posting about Tracy B's free workshop that she has coming up, because we have a lot of people asking about pro se in here. So that would be a good opportunity for them to listen in more, and also refer to her podcast, which has a lot of great information as well. Here's the last one that I have for right now is, if the difficult spouse has constantly evaded financial discovery, including mandatory disclosures, and you have had to file a motion to compel, how likely is it for the judge to grant your MTC and grant the attorney fees request submitted with the MTC?
Adrian, you first.
Yeah, I can take that one. So from a multi-represented perspective, motions to compel discovery are typically going to be granted, but they're going to give them time. So it depends on how much you've asked for. It depends on the timeline you've asked for. Have there been objections made to the discovery request already? They'll let them make those objections. As far as attorney's fees, it's hit and miss. I would say I never counted on getting attorney's fees during any motions, unless there was an issue of a party not having access to funds to pay their attorneys where the other party maintains access to cash to pay theirs. So I wouldn't think you'll probably get that. That would be a part of your settlement or request at trial, would be to get fees. A court might grant fees. It's always worth asking, but I would say and your attorney will know that better than I do, because I don't know your municipal, state, county level, city level, whatever it is, proclivities. But in Missouri and St. Louis County, fees are not the favorite thing by the court to grant unless there has been an attempt to act in bad faith. And even then, the court is still just not a fan of giving fees in the middle of the case because it goes back and forth. Is everybody's going to request fees all the time on every motion. And so they would rather deal with that all at the end.
And I don't think lawyers like to ask for fee, like even when
ask for fees, I put it in any motion that I filed where I had a difficult other side. I just rarely got it because, again, I was representing high net worth, messy, big, giant divorces. There was usually plenty of money, and fees were, when you asked for fees in my situation and my cases, I was mostly looking at them as kind of punishment for bad behavior. And the court doesn't really like that. So,
not to mention actually getting the fees that's another beast in and of itself. I have judgments out there to this day from 25 years ago that for attorney's fees that I still haven't gotten. And so, and it was just too much of a hassle to pursue. So I just gave up. So that's a whole nother beast. If you're pro se though, you can't ask for attorney's fees, of course. Right. But doing a motion to compel as pro se is especially against an opposing counsel. You might be, trying to climb an uphill, but it's almost impossible. What happens though is, like Adrian said, the judge will give the opposing counsel and their client more time, but sometimes it's a strategic thing for you to do just to file it in and of itself. Now, the problem is what pro se litigants want to do is keep filing. They want to file motion to compel after motion to compel after motion to compel, and that's not the thing to do. Because the other, as I mentioned, judges doesn't want you in their courtroom to begin with. So constantly filing these motions, and pro se litigants love to file incessant motions. And one thing that my audience is aware of is I'm not a fan of you just keep filing motions incessantly. It's just not the thing to do as pro se, because you don't want to piss the judge off by making them work more than they actually want to work on your case. Again, you're actually confirming to them that you're this problem pro se litigant and you don't know the rules. You're not trying to learn the rules, and so you keep resorting to filing motions. Just because you could doesn't mean you should. And so whether you should be filing a motion to compel, and maybe, once or twice, but to keep, and again, we know opposing counsel is going to play that game and, continue to ignore them. But what you do about that is not necessarily filing motion after motion.
Yeah, I mean, they're just typical tactic in the court is to not give you documents.
If you cut out.
Sorry.
Emily's having a glitch.
Oh, okay. I thought it was maybe me. But I just wanted, I don't want to derail what everybody's talking about because I think we have other questions coming in. But I just wanted to give you a real life version of what happens in court, because that's where I was this morning. And that's why I was delayed a little bit, because I was testifying in court. Well, let's just say I was supposed to testify in court. And this court case had been going on for 5 years. And this is like the third time that the trial has been scheduled. I saw a whole bunch of my friends at this lovely courthouse today, and I am in a different state, in a different county, so still saw a lot of friends. And at the end of the day, they went into chambers at the beginning of the court, and the judge said what the judge likes to do, which is, I think that this is what I'm going to have an opinion on. And it was the valuation of a YouTube channel. And so I'm just saying, probably deep in the heart of Illinois is probably not the most advanced people to understand online marketing or YouTube channels, but who am I to say as the expert? And the judge basically said that she would split our two values in the middle, and that she would split the personal goodwill issue in the middle, and that the value would be XYZ, and that they should just settle it, and that, he should just give her his portion of the house, and of the equity, and they should walk away. And so that was what, my client received again after probably 5 years of hoping she has her day in court. She did not get her day in court. And they, kind of threatened all of these other things. We had kind of a little bit of a toxic attorney on the other side, a little bit maybe of a toxic client. Kind of typical, but it's just a good example in real time of how, it was really hard for her to take that offer. It was really hard because it was half of what she anticipated was a possibility. And she was willing to, by this time, lawyers already paid. I've already been paid a trial retainer. I've already done all the work. I'm coming in to testify for one last little hour, of which we waited there because they saw a bunch of other cases first at the very beginning, and not saw them, but, talked to them for at least an hour of 5 other cases. And then they went into chambers. So me, her husband, the other expert, were all sitting on a bench, uncomfortably so. And she then had to say, do you want to take this? Or do you want to go to trial? Because you still could have gone to trial, but the judge was indicating exactly what the judge was going to do. Now, the judge did claim she had read both reports. I don't know how that could have happened. But again, this is and do I think that this is fair? Do I think this is justice? Do I think this is your day in court? No, but this is reality. Like, that you need to settle in some capacity a year before, 2 years before, 3 years before, or else you're just going to have a ton of fees and we're going to be at the same place. So I did not testify. She chose to take the offer. We did sweeten it a little bit with a couple things that we requested, because I think the other side, this was the offer that was on the table for the past year. This was our offer that was on the table for the past year, like minus maybe $10,000-$20,000, but they at least spent that in attorney's fees. So I just think that, again, going pro se is a very difficult position to go in, but we see a lot of clients that are, at their wits' end. I have a client that just fired their attorneys last week after spending $60,000 on attorney's fees for a year, but also forensic fees that the attorneys spent $30,000 doing their own internal forensics and analyses, of which, didn't really benefit in much. And so she's like, I think I'm going to go pro se. And I'm like, you need to talk to Tracy, because there's not a lot of people, even Adrian, I think, has talked about, like, just because you're a lawyer doesn't mean you need to know how to go pro se. Just because you're an expert doesn't mean like, that's the first question she asked. She's like, well, what should I file in the court system? I was like, ma'am, all due respect, so she's actually talking to a lawyer who really acts as a mediator, who can give her some legal advice, and I can give her the financial advice. But I'm like, I don't know how to traverse that land, even if it is, and I have a few clients that are pro se right now that are doing a phenomenal job.
Yeah.
But they're spending, it's their part-time job to
Yes.
research, to document, to, make sure, and then seeking out people like Tracy B, because I think she actually did seek out Tracy B, to get some advice. So waiting for your day in court, that's not the focus. Even if you're pro se, it's, okay, how do I continue the litigation track long enough to see if the settlement track could prevail? And in this situation, the settlement track prevailed literally an hour after court was supposed to start, so just the true life of an expert.
I do want to, what Melissa said about your day in court, I want to just enlighten a little bit there is, yeah, the court is not just scheduling your trial that day. So what she said is 5 other cases. It can be 3 hours. I've had plenty of trials that were scheduled at 9 a.m. that started after lunch. The court is operating for everyone, not just for your case. So you're going to wait. no matter who you are, no matter what attorney you are, you can be the biggest hotshot attorney charging the highest fees. You're going to sit and wait for the judge. At some point, you're waiting. That's why big attorneys are sending their associates, because they are not going to go sit and wait for the judge to come out. That being said, so you're going to sit there, you're going to wait, and the presumption is that your attorneys are going to be trying to negotiate and settle your case during that time. The oddity here is that, maybe the expert report, I know we had it done a long time ago, maybe the other expert didn't have it done until more recently. This is what a judge would be usually telling you during a settlement conference or a status conference is, this is probably what I'm going to find. I'm probably going to split the baby. Split the valuations. I'm going to go in the middle. Judges are not an expert in anything except law in the state where they are practicing. That's what they're an expert in. Plenty of them didn't practice family law. So you're going to have a judge who maybe doesn't, all they know from family law is the process and what they've learned in like judge trainings. So they don't know, they also don't know finances. They don't necessarily know money. They don't know business valuations. And so those are the things where even if you hire the expert witness, the judge is still going to say, well, I can't differentiate between these two reports because I'm not an expert on this. So you often end up, I don't think I had a single case that went in front of a judge that had two valuations where we didn't end up with in the middle number. This is how I knew Melissa. She was an expert witness on several of my cases. And we had a case where we worked on it for 3 years. It went to trial. It was a 7-day trial. And we thought we were going to have 2 days of expert witness trial. And the experts came up with values that were about $500,000 apart in a multi-million-dollar, $25 million, which is nothing. It's very, very close. The judge was still going to split it, right? Even if they're close, even if they're far apart, if the judge doesn't feel like there's been manipulation and they believe that both expert witnesses have strong ethics, have good resumes, are, utilizing the same information, that's the way they're going to most of the time deal with.
Well, and we could have gone after probably 40 more thousand, 50 more thousand, maybe, but then you're getting into the level of nuances that like I was trying to describe it to my client who's kind of an author, and I was like, that's like me saying like all genres of books are the same, like all of fantasy is the same, and no, they would be very different, or any of these, there's nuances to what we would have been fighting about. The problem was that when you have a judge do this, which I don't like, but it happens all the time, is that they have already made an opinion before we've moved forward. And it's going to be very hard for me to get them off of that opinion when their opinion was literally just splitting it down the middle. So then I'm saying, okay, I'm trying to convince them to go moderately to my side. And this is basically all issues in court. Like, if you're fighting for a motion to compel, if you're fighting for any of these things, they haven't given us documents. Oh, well, you don't need those. Like, everything has a perspective, and the judge is sitting back saying, oh, maybe both of you are crazy. Maybe both of you are the problem, right? And so they're not seeing your nuances of, hey, this person is like traumatizing me, is abusing me, is doing all of this, and they're coming in and they're saying, well, actually, I'm spending the money on our marital, expenses. Like, every side has a perspective, and the judge looks at it as like, okay, they both seem reasonable. They would see both of us experts as reasonable. The judge even said that. She was like, both of them seem rational. I'm going to take it. And some states you have to pick one expert. For the most part, the judge is just going to try to have come somewhere in the middle. And if they come somewhere in the middle, you don't really have an appeal either. And this is all legal, so I'm not trying to give you legal advice, but in my experience, if the judge comes somewhere reasonably between those two experts and has a logical way of going about it, you're probably not going to be able to just appeal that situation. And so now you're kind of stuck. Do you take a chance? And I don't know, like, when a judge tells you this stuff up front and you decide to just take your chance and continue forward, because we have in other cases, I don't think the judge looks kindly on that either. It's almost like, oh, so you're going to continue to waste my time, for the next day, and I already told you what I'm going to have an opinion on, and you're going to pay lawyers to give, like, sometimes they do these things like facts and findings afterwards, which basically they're saying what the judge should do, and the judge is still going to do what they want to do. So you're taking a lot, and again, all of us have been through the legal system quite a bit in our careers. There is zero chance that we can predict what happens. And, like, I actually thought that I was going to, I was moderately pissed. So was my client. Like, I was ready to go to town on this one. Right. But for the client's best interest, I had to counsel her on that financially. It was a good deal, because it was like this. Obviously, we're there because this person wanted to give her nothing. And the fact that the judge was at least giving her, a really good outcome, that what could we have gotten maybe, and if this was like, big dollars and we could have gotten $20,000 more. I mean, I just don't know if that would have been worth it, to take that chance.
And remember,
So-
those days in trial are both of your attorneys charging potentially up to $1,000 an hour combined if they have paralegals there or anything like that. So you're already talking about a trial day is probably going to cost you $10,000, let alone all of the follow-up after trial, which is more complicated. As Melissa said, facts and findings, we do that in Missouri. I think we do it sometimes in Illinois as well. When you have to do that, it's even more work. And then you're waiting, and your attorney's waiting, and the judge is waiting. So it takes more time as well, because judges do not write their decisions that day either. They are going to sit on it. It'll get issued sometime, hopefully in the next 60 days. So if you want to be divorced and you don't want to pay for a trial day, like what Melissa's saying today is, that the cost of trial and the cost of all of those post-trial motions and post-trial activity should come into play when we're talking about a $10,000 difference, because it is the cost that you're going to end up paying the lawyers instead of getting for yourself. So,
and she's divorced. Like, they were writing up the documents while we sat there. They were going to sign, submit it to the court. She was going to be divorced today, and she's bawling in the hallway, and so you have to understand, like, this divorce day isn't this kumbaya like celebration. It's this 5 years of trauma. She's like, my kid was going through 5 years of this. Like, I missed time with that. I missed, like, it's a grieving period. And I told her, I was like, you're going to grieve about this. Like, maybe go and drown your sorrows if that's what go and punch a punching bag, like whatever it is. It's going to be anger, it's going to be frustration, it's going to be sadness, it's going to be like, I got screwed, but like, did I have any other choices? I mean, this wasn't coming from us, this was coming from a judge. And somebody said, well, shouldn't you just have gone high and they go low? That's what everybody does. That is the problem, is you go high and you go low, and the judge is like, well, they seem reasonable. Let's split it down the middle. That's why Adrian calls it split the baby, because that's what we low key call it. But this is happening all the time, and it is very frustrating because you think that the court system is just, okay? And again, going pro se is going to save you a ton of money, but it's going to exponentially increase your stress and anxiety about whether you're doing it right. And they're watching to let you mess up. They're like hoping that you say the wrong words or don't, object at the right time. But even getting through like a deposition phase, I think is a good time period to be able to be pro se, because there's a lot that you can get, if you show up as a good deposition and take a good deposition for yourself, and do that, like even getting through those time periods. But if you have a toxic spouse, you might have to go all the way only to settle it on the courtroom steps. Like, that's why this percentage of 80 to 90% of cases settle on the courtroom steps. This is it. This is what happens, and there's not going to be much that you can change about it other than to make a more compelling argument sooner, to get some of the, make an offer even with limited data and have them force you to be wrong by presenting the data. Like this guy tanked his business in the last year. Like we updated the valuation, incorporating the most recent year because we had to, and he tanked it, like half of the revenue, right? You know, you don't think he's going to go make it back? Of course he is. But we don't, it's still like he could present a very compelling argument about anything. And the judges see these types of situations 100 times a day. You're not unique. They're going to see both sides. And, you know, even in egregiousness, which somebody asked about, you know, financial abuse and parental alienation and 20-year, you know, does the court care about that? I'll let the other ones talk about that, but no, they don't. You know, this is really, it's an eye-opening experience. That's why we do this community and this group, so that you're not going in thinking that it's like the movies and there's some prevailing day that
Justice
happens.
is not always served.
Correct.
Yeah.
Tracy, what do you think? What's going on in your brain, Tracy?
You're right. I mean, I'm thinking too, you know, a lot of what I do is to give them, you know, I unlawyered my brain in the past 6 years. Working with pro se, I've learned to see things from their perspective. And lawyers are going to talk the lawyer stuff. They're going to talk about, you know, the judge and, you know, justice and fairness and the process from a legal perspective. And I did that. But now pro se they don't care about that. They don't want to hear that. A lot of them actually, when I start talking like a lawyer, they're like, they're turned off, because that's not why they're coming to me. They want the truth. They want the ugly truth. They want the reality. They want it as it is. And so that's what I tell them. I describe to them, hey, listen, let me tell you, it's not going to be fair. It's not going to be just. Nobody's going to walk out of there smiling and happy and ready to sing Kumbaya. But it's over, right? You've gone through the process. You've learned some things. You've grown, but it's actually over. The reality is, you have to decide if this is what you want to do. If you want to be pro se, it's not a day in the park. It's not a day at the picnic. You're switching. You're not spending all this money, but you're going to spend some sweat equity. You're going to have to put some time and effort to it. And when people come to me now and say they want to be pro se, I screen them now. I say, hey, listen, you want to be pro se because, or maybe you don't, you're forced to be. Either way, let me tell you what it's going to look like. It's going to be like being back in school, where you're spending a few hours a day, just doing research and just understanding things, and even talking to me, because the things I'm going to tell you about the family court process, you're going to want to go and look up yourself and talk to other people. And that's going to require some time. So I'm glad you actually described that, because, you know, it's not like TV. It's nothing like TV. It's nothing like, I'm sorry, Adrian, but it's not even anything like what your lawyer is going to explain to you, because they're going to pretty it up to some degree, or they're going to be diplomatic, or they're going to be, you know, they're going to use terms that are more friendly to their colleagues in the process. Where I am, I don't have an allegiance to anybody. I'm going to tell you the ugly truth. I'm going to tell you that, someone said to me the other day, this guy, he's a new coach now. He's a pro se coach. Has no legal background like a lot of them do. He calls himself a pro se coach, and he has one case under his belt, and he said to another audience member, hey, judges don't force people to accept offers. And I'm like, the hell they don't. Yes, they do. What are you talking about? He said, no, they can force you to the process, but they can't force you to accept an offer. I'm like, they do it all day. What are you talking about? And I hate when people tell people things, again, the pretty version of it. No, they do it all day. They use their authority. They use their influence to get you exactly what you just said, Melissa. I'm giving you a hint. If this goes to trial, this is what I'm going to do. That's not forcing them to accept an offer. Sounds like it to me. But, you know, I had to interject. Hey, listen, he doesn't know what he's talking about, because he's been in one courtroom. I'm telling you, they will actually force you to accept a number that you don't want to accept. You have to be ready for that reality.
I've got a couple on what you guys have said. Is first of all, why would you? I'm going to answer a question that I haven't seen, but I see a little bit of a take on it about why two different valuations. So why would you actually say the judge says this, but I'm going to go ahead and I'm going to go to trial? What happens? Typically, the only time I've tried to do that is the judge says I'm going to do this and we're going to take it to trial. Typically, it's an issue and not everything. We're going to talk about one issue. Not going to go to court and talk about the division of your retirement accounts. We're going to go in, and if the issue is the valuation or the issue is a custody issue, the reason you're going to take it in front of the judge and go to trial is because there is an issue with the way someone else has done something. So if you've deposed your expert witness and your other expert witness, you know what the problem is, and you've probably tried to settle it. But maybe they're going to say like, no, I'm going to use this valuation method that Melissa and I know is only if you are doing an ongoing business, but we're talking about a valuation method for a date and time. So we need to value it under a certain methodology. Now we can go out there and tell the judge they used entirely the wrong methodology. This is the issues with it. This is why. If I had used that value, if I had done that, that would be, this is a technical issue with the valuation. The judge is going to hear that. They are going to look, and they're going to look at those kinds of issues and actually hear evidence to it. If you're just going to go out there and say like, Melissa says this number, another expert says this number, that's the sort of thing where a judge in chambers is typically going to tell you, I'm going to divide those numbers because I'm not an expert on how to go about that valuation. That's why, for example, we had valuation where they were less than 5% apart on the value. In the grand scheme of things, that's not very much. Not a small dollar number is $500,000, but the reality was both valuations were valid. There are a lot of assumptions in a valuation that you can take and make. And that's when you work with your expert witness to come up with their questions, to talk about their assumptions, and you work with them to come up with the questions for the other expert witness about things like assumptions. And why could your valuations be drastically different because you took a different set of assumptions? And the same thing with other, any expert pieces. That's typically, we're going to go to trial because we're talking about something where we have a fundamental disagreement about how to go about it.
And they got it wrong. Like categorically, they applied the wrong valuation methodology to the wrong thing. And I mean, we would have had them dead to right. Not only in the fact that like I have intimate knowledge about the topic as well, but at the end of the day, it did, like, if I would have said, let's continue to go to court, when we talk about anchor the deal, the judge anchored the opinion. And so the moment that the judge anchors the opinion, we're going in because it would have been, because interestingly enough, I really didn't think the other side was going to agree to it. Right. And so I was like, well, let's just see if the other side is even going to agree to what the judge said. And they came back and said, yeah, they would agree. And I was like, dang, we haven't gotten them to agree to anything. And so I can't just go to trial and say, hey, I think I can fight this. Right. I think I can get it, because they don't understand the nuance of valuation theory. They're never going to I'm fighting an uphill battle in this capacity. So I had to say, listen, I can fight it. I can get them to go towards our side, but we're basically telling the judge that we do not care what she said. And that's going to have a tint of it during the entire testimony. And I think she would have let the two experts testify. I don't think she would have let the two, and the attorney had already predicted that this was going to happen. Like, he thought she'll let the two experts testify and then give us some indication of what she's going to do. We didn't anticipate she would do it beforehand, but there were, in both cases, we've done extensive reports. And so she did have the capability of reading some of it, but the nuances of it, which again, we're talking online marketing, YouTube, like we're talking some complicated things that normal people don't understand. And there would have been a nuance of it. And I would have been more credible in that, which means they would have just come for me in other areas, right? Like, they didn't like a couple other things that I've done recently. And they certainly, have probably watched my own YouTube. Because whenever I pulled up about this topic on YouTube, who do you think's videos showed up? Mine, right? So at the end of the day, you have to do what's best for the client, regardless of if my ego wanted to go fight it. And I think the attorney wanted to fight it too, but we've been in this situation, and and this is the nuances for anybody's case. Well, this person was abusive to me. This person was infidelity. This person spent money, gambled, any of these issues, right? Or it's a separate asset. It's like all of these are nuanced in theory, yet it's sometimes lost on how, when you think it's really important to your case, right? It doesn't mean that that's going to land. Even if you think it was illegal what they did, which is a lot of the civil stuff, right? It does not mean that the court is going to say that it was illegal, because they're going to come in and be like, well, I gambled, but sometimes I won and sometimes I lost. Or, you know, like, they're going to have a reason. And the court, you know, like, even they don't disclose all of their assets, right? That's a big one. That's like, well, that's illegal. Okay, you know what they're going to come in and do? Oopsie, I'm sorry, I forgot it, but it only has $5,000 in. You're going to think, oh my gosh, the credibility is lost in the court. And the court's going to be like, people make mistakes, right? They're going to give them the benefit of the doubt because they're giving you the benefit of the doubt in other areas, but you're not perceiving it. So it's a lot of perspective. It's a lot of, you know, I think you can go pro se for a lot of the time period, but they're going to press you to take it all the way, because at the end of the day, where you don't have a level playing field is in the courtroom at all times. Like, you can negotiate outside, you can have a level playing field in mediation and negotiations, but the moment you hit that courtroom, regardless of how well prepared you are, they're going to come for the jugular with you. And it's going to, you know, like, it took me 5 to 10 years to get good at testifying in court. So I just, you know, like, you're going to second guess yourself, which is the harder part. So if you go into pro se, you just have to, like, have the confidence and the wherewithal and get the right training and understanding of it. But that doesn't mean the court's going to give you, like, oopsie, you didn't say the right objection. You didn't have a valid reason for the objection. Like, they're not going to necessarily give you a pass. Like, judges don't always look favorable on pro se either. You know, it's an uphill battle. So at some point it might be that you would have to find a lawyer at the end to try to take you to go to court. Oh, but wait a second, that lawyer's not going to do that at that point. Oh, wait a second, they're going to want $30,000 because now I got to get up to speed on it. You know, so it's really not, it's just not a just system. So trying to settle, trying to negotiate, trying to do some of these things, but showing up very solid as a pro se. Like, you still have to be very confident, because you have to sort of make them realize that you're going to take it all the way, even if you don't feel confident about it and you second guess yourself in general. Like, you cannot let them see you sweat. You cannot, because this attorney, even I heard him down there saying some stuff about me, and I was like, sir, like, you don't understand. Like, I'm mafia style lethal. Like, I'm gonna come for you and other. No, I'm just kidding. But, like, you know, he's just a despicable human, and so he was just saying stuff to the other side, like, oh, I'm gonna rattle her on this, and she does. They're like, it's all just blustering and bluffing, and, you know, these legal egos that happen at this time. So you have to be very strong when you deal with this.
That's that bulldog, that legal ego. People say they want the bulldog. You only want that bulldog in the courtroom. You don't want them for settlement purposes. The one, like, little quip, because Tracy said, like, you know, was talking about, you know, the words lawyers use, right? Like, we paint a prettier picture for our client. It's a tendency to be like, oh yes, I will solve all of your problems. That's why you hired me, right? Like, so we're going to paint a pretty picture. I don't think I did that. I'm just going to say personally, but my big thing that I told my clients when we came to settlement is, if you're not happy and they're not happy, but you can live with it, it's probably a fair, because no one's going to come out of it. Like, you think you're going to go to trial and you're going to try your case and you're going to put up your best evidence and they're going to do it. The reality is you're probably going to end up where you offered settlement in the past. It's going to be about 50-50. It's going to be this. I know people, you know, there are courts that take into consideration behavioral issues. A lot of the questions I'm seeing in the chat about, like, domestic violence and all that, those are legal criminal issues. And so the civil court is not going to, there are two court systems in the United States. There's the criminal court system that looks at those battery, assault, domestic violence, white collar crime, obviously, all of that stuff. And then there's the civil courts, and that's between members of the public. So that is businesses, that is individuals. And the civil courts do not go into criminal. So if you're talking domestic violence, like they are not going to take even evidence unless there is some financial aspect or some really serious previous or history of it. Unless we're talking custody, like custody comes a little bit differently for it. But the reality is the court's going to say, well, that's the criminal. Like that's over there. The civil court isn't an expert in criminal law. They're not going to make a value judgment on anything that you present about criminal behaviors, domestic violence, assault, things like that. In divorce court, the only things that I ever had a judge really care about in St. Louis County, the court doesn't care what happens in your bedroom. They don't care about cheating. They don't care about it. They don't care about anything unless you spent a bunch of money on your ex or on your girlfriend or boyfriend. I had a client buy a girlfriend a Lamborghini after being told, please do not do this. The court cared on that one. That was the only time that I've had a massive expense. The court will sometimes look at that as dissipation of marital assets. There it was very easy on that one. They didn't have to look at a lot of evidence. We just presented the car.
Well,
but obviously he was sending flowers. He was buying hotel rooms. He was doing all sorts of other stuff.
but if you know that your best case and their best case, right? Because their best case is probably your worst case.
Mm-hmm.
Split it in the middle. Like that is what's going to potentially happen in court. And it doesn't mean that you can posture up a huge value because the court's going to think you're not credible, right?
Mm-hmm.
You know, like they're going to think that both of us are idiots as the experts if we do that, you know, but at the end of the day, yeah, is that a smart move sometimes? But I think if you're looking at your best case, you're looking at what their best case is, and you can come somewhere in the middle, that's going to be what a judge is going to do on a good day as well. Now, somebody was talking about how they have an uncooperative spouse, you know, the attorney's saying, let's have his day in court, and all of these things are happening. I think I've seen lately that lawyers keep on pressing to go to court and to handle it in court because what I think is they don't know how to settle cases outside of court, you know, and they are not necessarily being able to mediate it. But also at some level, if your spouse is that toxic, you got to figure out how can you walk away, right? In this situation, I think I know this situation, you know, there's property, there's real estate involved. And the problem is if you can't just walk away and say, okay, I'll take nothing or I'll take some moderate small piece of it, right? Then you're sort of held hostage by that toxic spouse. And so you're going to have to continue to kind of move forward. And if they're pro se, let's hope that, you know, the court is in your favor in some capacity. Tracy, what do you think? Did you see that comment?
No, I can't see the comment. Wait.
Oh,
Thanks.
I can read it if you want me to.
Yes, please.
Can I flip on what Melissa said for 1 second? I'm sorry.
Yeah.
Is that's what she's talking about, the decision making that the lawyers are not doing. That's what settlement conferences and status conferences with judges are for, is to help you figure out where your pivot points are and get advice from your judge before you go to trial. So your lawyer should be utilizing that time to try to come up with a settlement with the other side and asking the judge those things like, what are you going to do with that valuation? That was all. Sorry. Just
I
right.
see the comments now. Let me just tell you this too. Pro se, especially men, they will fire their attorney just to be pro se as part of their strategy, so they can do exactly this. I mean, I hate to sound like I'm, making labels based on sex, but I've been doing this 25 years, and a lot of times the husband spouse will, actually get rid of attorneys because part of their way to manipulate things is to use what they can to, again, control the process. And one of the major things they usually do is defy court orders and court rules. And they do it for several reasons. But from a court's perspective, a lot of times, unfortunately, they know the consequences are going to be trivial. frivolous, menial. And so they're willing to take that chance because a lot of us, women are emotional still and vulnerable and easily, except people like myself, of course, manipulated. And so they use that as a tactic to get you to succumb or capitulate to their will, which is to completely control the process. And so if you're letting them do that, then and letting them what I mean by letting them is you don't know the procedure, you don't know the rules, you don't know what you can do, so you don't do them, you continue to react emotionally. They're actually winning, they're prevailing at exactly what they set out to do. So it's incumbent upon you to even more so understand the rules of procedure, the process, and to understand how to use it, especially against pro se, to your advantage. Because you want the court to know that it's not you dragging this case out and making it stall and being high conflict. It's the other party. So you can actually change the direction of this case when they are doing this stuff. You have to know exactly what you're doing. You have to actually create a game plan of your own to kind of offset exactly everything they're attempting to do. You have to read. I am a strategist. I know the legal process. As a strategist, though, I incorporate the practical, the tactical, the logical, everything else we can possibly get our hands on and use to our advantage to ensure that this opposing party, this pro se opposing party, is not going to continue to manipulate and control how this process proceeds down the line.
Tracy, what about parties that go in and out of lawyers, in and out of pro se, and use hiring lawyers as a delay tactic?
That too. That's another thing they do. And again, you know what though? People who do that, especially when my clients do that, I tell them to stop doing that. I say to them, again, that's not the way to do. Going through a revolving door of attorneys is not a good thing, because you know what it does? Again, it's delaying the process. And you know what that means? The court is actually being dragged into your stalling tactics, and it's not necessarily a strategic move that's going to be beneficial to you. If you have to use attorneys as limited scope or consultants or coaches, so be it, because they're not on the record. They're not presented in court as the attorney of record. So that's different. But when you're hiring a lawyer and then you're firing them, or you're constructively firing them by being an asshole, excuse my language, and they fire you, it's the same thing. I'm not a fan of pro se who do that.
No, I was saying as if the other side is doing that
too.
You're trying, yeah.
Let them do it though. Yeah, let them do it, because you know what this is? The rope. They're tightening that rope right around there. Yes, let them do it. Sure.
Now, there's something that I know about this case, which I think will give it some interesting piece of it, is that in this case, I think that he will fail as pro se. And so I think that the attorney is making a smart move by trying, because the other thing that happened in this case is there was a bad judgment about an issue early on that the lawyer failed bad. And I don't think in this situation, I think they almost have to go to trial, because A, this person is relying upon that bad judgment. B, that they're probably going to get an outcome that's not going to be super favorable. So you're hoping that the pro se person messes up, or literally there's a possibility that he doesn't show up to trial, right? Because he doesn't know what date things are, or things like that. But at the end of the day, I think that in a lot of these cases, like today, because we didn't go to court, we have no process of appeal. Zero. We've settled outside of court. If you settle in mediation, you got no appeal. You have to allow the judge to give you an opinion, a judgment, in order to appeal something. And so in the case that she has, I think that she's not going to have the capability to go back to that other issue that is certainly probably has some appealable issues in it, unless she kind of moves forward. So, in some cases, I think, Tracy, you're right. If you're on the other side of pro se, you have to use it against her. So if that's what people are doing to you, you have to make sure that you're prepared for that. You're knowledgeable about, you know, what you can do and what you can't do. And you don't worry about what you see on the movies. Like, you really work with, you know, if you're going to be pro se, and we've said this before, this is why we have Tracy on the show. It's not just because we like Tracy, but it's because we are not equipped to tell you how to go pro se. It doesn't matter if I've been 25 years in here of doing it across the country now in like 15 to 20 different states, seeing all different courthouses, right? All different processes. It does not mean that I have one iota of understanding of how to go pro se. And Adrian and I talk about this a lot, you know. So again, if you're going to do any of this process, make sure you partner up with the right, like, you're going to negotiate a settlement. I want you to talk to us about how to negotiate that financial thing. But you have to assemble this team of people that give you, like, you do a bunch of the research, you do a bunch of the legwork, and then bring Tracy in and say, okay, here's my 800 million questions about what to expect. But in the situation on here, I think she's being counseled right. He is a loose cannon, and they got big dollars involved, and they're going to have to see what the hope that the court sides on her favor, given all of these bad, you know, reasons or whatever. We have one last question, and we've gone over, so I think we'll try to wrap it up a little bit. In a business valuation between two competing experts, is the biggest difference in the value coming from the assumption around how each expert values the personal or enterprise goodwill? No, it's, I'll tell you, this is a very easy answer. Everything comes down to cash flow. If you really look at it, it's not discounts, it's not cap of earnings. This might be educational for everyone here. It is cash flow. And so at the end of the day, there's adjustments that are very subjective when we adjust the cash flow of the business, but cash is king. Why do people buy businesses? Like, I was actually encouraging them to put this company on the market because I would have bought it. Like, that's how much I was convinced of the value. And even then, I mean, literally, I would have bought it. But even then, at the end of the day, personal and enterprise goodwill only comes into play when you have a professional practice. So if you have a real business, like you sell, you know, products, you sell tangible goods, personal goodwill isn't going to come into play per se in that, because it's not, there's passive and active appreciation, which is a different thing that you can Google. You know, that's for a separate and marital asset. But at the end of the day, no, it has nothing to do with discounts. The discounts are subjective too, and you can argue those, but there's reasonable ranges. The capitalization rate should really only be somewhere between 18 and 25% right now. And, you know, the discounts are in certain ranges, but, yeah, if it's a professional practice, hell yeah, then sorry. Thanks for clarifying. Then that would be one of it, but it's still cash flow. It's still a double dip concept that you need to search up, and we can talk about more. But no, those three are going to be cash flow, double dip. So if there's alimony or maintenance, and then yes, then it comes down to personal and enterprise goodwill, which right now, the only ways to quantify that is purely subjective. Like, there is no, you know, like, reference point that says it's a certain one. There's like Goodwill Registry, which is for like dental and medical practices, which give you a base. I actually reach out to brokers so that I can know what the difference is in personal goodwill. But that, yes, that is one of the things that you'll fight about, which again, in this case, that was it. Like, we said none, they said 75%. The judge was like, I'll go in the middle. And I was like, no, I'm going to prove, like, no, I'm going to prove my position. And the other one, the 73% was like freaking outlandish, like outlandish. But do you think that the judge understood that? No, you know, so they're just like, oh, they're just numbers, you know. So that's what, oh, the kitty's telling us to exit stage right.
Right? Cat's like, I'm done with you. I need my owner. We're so glad to have all of our experts on every time that they get to come on. Tracy B and Adrian, thank you so much. I do want to remind you that Tracy B is having a free workshop. I did post it in the comments. So if you're wanting to know a little bit more about pro se or how to handle some certain things pro se, I mean, this looks really interesting. Diagnose your family court case, find out why some cases spiral out of control. Okay, that all of you are in that boat where it's spiraled out of control at some point. The divorce allies are always here. You can also check out the divorce vault for any of our other additional resources. You're going to be getting an email probably Friday, right? With the recording from today.
I would say even if you're not pro se, the thing is you start to mistrust your attorney because your attorney practices in one county, in one state for their whole life, right? And maybe 2 counties if you're lucky. But like for the most
states,
they're just like, they have this one track mind about how things work, and that's not always how it works. So I think just to have a different perspective, just to understand what's happening in court, I think would be good. So I would join Tracy. Who knows? Maybe I'll hang out and learn something as well. So, but we appreciate you very much, Tracy and Adrian, and we'll look to have you both next month, or sometimes we have one or the other. So however it works. But Tracy, what other things could we talk about in the future that you think would be important? And you're doing some stuff online too, answering questions, but you want any last parting things of what people should be mindful of as they're going down this path?
Yeah, one topic that's really been reaching, we talked about it before we started, is stay-at-home moms who are coming out of marriages where there are assets and, a huge disparity in incomes. That's a huge topic, and that's a huge area of law, family law, that a lot of people would probably be interested to discuss at length. And I have a lot of insight about that, particularly when there's an imbalance in financial resources and you want to get access to those resources and you want to do it with or without representation. Yeah, that's a great topic to actually
I'd like to talk about that too, from like keeping the house or qualifying for a mortgage as well. I'd love to jump on that topic because it's a little trickier when it comes to those requirements. So yeah.
Don't you think there are more pro se and custody issues than probably in higher dollar or no?
Yes. Oh, for sure.
You know what it is? A lot of times when there's higher dollar, it's not just the custody. They want they want temporary support. They need support. They need to figure out how to divide the assets, and they don't have money to actually hire somebody to get that. So yeah, custody is an issue, but there's a lot of people, stay-at-home moms, who, custody is issued. That's why they're stay-at-home mom, although some of them are just stay-at-home spouses. But a lot of it is the finances. A lot of them just want access to the finances. They don't want to be cheated. The spouse wants to negotiate settlement. And so they want to know if settlement is a viable route for them. So there's a lot of non-custody issues that come up for them. Absolutely so.
And what Tracy said previously, which is if you are a pro se, like when we talk about if you can hire an attorney, a lot of people are going to, because the amount of hours that Tracy is saying, like several hours a day that you need to be dedicating to your divorce case when you are pro se, when you're a stay-at-home mom, or a stay-at-home parent, that is even more difficult because your whole day, your whole evening is taking care of your kids. So there is some even more complexities to just the time allocation and how you can move things along. So I'd say that's probably why when people have the resources to hire an attorney, when they are stay at home, they're going to. It's also the method. Often, Melissa, you see this too. When one person stays at home, money starts to get really, really tight for them. And so you often are hiring an attorney to make those temporary order motions and all of that.
That's huge.
Yep. Financial abuse is the biggest thing of the pressure to settle. So, all right. This is awesome. Somebody said disabled divorcing spouse too. So we'll keep that in mind for the future. I think that would be good. Gray divorce, all of these things. But I think specifically for Tracy, it's, you know, some of these pro se and going through some of the hearings, or, you know, how to protect yourself and continue to do the research and sources and stuff like that. So, but she always has workshops going on. So if that's what you want and you want 100% of the time, go there, because we're only talking to her once a month. And I think that if you're really going pro se, you need to get a lot more consulting in that space, because even I would be a little bit concerned, because
Even if you're considering pro se, you don't have to be sure you're going to be pro se. But if you're considering pro se, or you're in between attorneys because you want an attorney, but you want to make sure you hire the right attorney at the right time, those are things I help out with as well.
yeah,
And establishing that baseline from the training you're talking about, like, it's so important. You don't know what you don't know.
Absolutely.
And
Yeah.
Tracy can set you up with the baseline of what you need to know. Even if you hire an attorney, you're still going to utilize what she's telling you, because it's timeline, it's approaches, it's all of these really important things that your attorney might tell you, but you're going to pay for it, a lot of money for it.
yeah. Stop asking your attorney procedural questions. You're just going to get charged for them to
That's
tell you how to do
$600
their
an hour.
job.
No way.
And they hate it too. Okay, somebody said this information is gold, so we won today. Now I got to drive home for like 45 minutes, but awesome. We will see you guys next week. Next week, I have no idea. Actually, next week is a free
No,
for all,
it's-
because what?
It's on Anna, isn't it?
No. Oh yeah, maybe. Who knows? What next week
I
is.
think we're
You'll-
talking about creating businesses and getting ourselves paid next week with Anna. Then
That's
the
right.
following week, because it's the 5th Monday of the month,
Yeah.
so we have no plan, but we do have a plan, because I know Melissa's going to hop on by
That's
herself.
the week that I'm excited about, because I'm going to do something crazy.
She's just
And
gonna,
but yes, next week is still scheduled. So dang it. I thought next week was my fun week, but
sorry, it's
the
not.
following week. All right.
No
Well,
worries.
we'll see you guys soon. Appreciate
Okay.
you.
Thank you.